how is the division of marital property handled in Colorado in a divorce? It is the bedrock principle that assets and debts, which are really just negative assets, should be divided equitably between the parties. A lot of people hear that and hear equally that it's got to be 50-50, and there's no such law. Equitably means fairly. Now, you can imagine that in many circumstances, fairly and 50-50 are pretty close to one another. But in a lot of circumstances, they're not, because there are differences in how the assets were acquired. There are differences in how the assets were spent or wasted during the marriage. There are also notions of separate property. So in Colorado, what you came into the marriage with, if you don't commingle it with other things, is often considered your separate property, and you leave the marriage with it. And it is not divided equitably between the parties. And then, of course, this is where everything gets interesting. Because if those separate assets are substantial, they can have some effect on what would be fair, what would be equitable in the division of the other assets and debts. So the division of assets and debts in Colorado is handled equitably with a knowledge of the totality of the circumstances, everything that's gone on with those assets and debts, and what the rest of the estate of each party looks like, so that the court can make a determination of what is fair. Truth is that in most divorces, the parties make agreements as to the division of assets and the division of debts, and a lawyer on each side can really help to facilitate that process.